In this video, I will offer some comments on the matter of retail price maintenance clauses and whether these should be viewed as anti-competitive by object. This is usually assumed, but the theoretical basis is weak at best, and in a recent ruling from a Swedish court, it is apparent how uneasy the court was about condemning the arrangements under this standard. One judge even rebutted the traditional approach, suggesting not to accept retail price maintenance clauses as anti-competitive by object. This video will discuss whether the Swedish court reached the correct conclusion and why the current approach to retail price maintenance clauses is too simplistic. First, some context. Retail price maintenance clauses, also called RPM, pertain to situations when a manufacturer dictates the resale prices of its customers, typically to maintain a higher level and limit price competition. Usually we take a relaxing approach to vertical restraints under Article 101, but RPM has persistently been seen as detrimental to free competition and in defiance of Article 101, regardless of any proof of actual damage to competition. Inherently anti-competitive restrictions are labeled as restrictive by object and can be deemed illegal with limited consideration to context or effect once identified. In contrast, restrictions falling short of this must be assessed against their effect, and in practice, enforcers do not pursue such cases. For all practical purposes, the line between restrictive by object and by effect also marks the line between being legal and illegal under Article 101. I will not explain why economists do not see RPM as problematic, or how enforcers have not prioritized the matter for years. But to provide some context, think of this example. Online shopping is gradually displacing traditional brick-and-mortar shops, as the latter are expensive. This comes at the expense of the overall consumer experience by making conventional pre-buying services, such as testing the product or soliciting advice, impossible. This does not reduce consumer experience for simple commodities, as the product is generic, and sufficient information can be provided in the online shop. For others, it is more complex. Granted, you can order different sizes or shapes of clothes and return those you don't like or fit, but not all consumers are confident about this. Moreover, this does not work for home interiors or high-end electronics, where pre-shopping advice is at a premium. Many manufacturers fear that consumers will show up in the brick-and-mortar shops, drawing on their services, but then make the actual purchase online at a lower price. This development will undermine the ability to run physical outlets and eliminate brick-and-mortar shops in the cities. Preventing online shops, with lower operating costs, from offering lower retail prices is a way to protect the brick-and-mortar shops and ultimately the end-user experience. As already explained, I will not detail the pro-competitive side of RPM, nor will I detail the legal treatment and how the theoretical basis for identifying them as inherently evil is weak at best. If you want to know more, I can recommend this outstanding book. It compares the EU and US approaches and shows the lack of consensus in theory on RPM as inherently bad or anti-competitive. Returning to the matter of object restriction. It's easy to understand why we have this group of restrictions. An advocate general has referred to risk offenses in criminal law, e.g., driving under the influence of alcohol or drugs, to justify why we have a catalog of object restrictions. The question is not whether we should have a category of object restrictions, but whether this involves a predefined list of crimes and what to include in this list. For many years, it was assumed that the notion of restrictive object was a closed list, which was occasionally expanded or reduced. Some have even referred to an object box and a menu of object restrictions, but this is no longer tenable. Today, it's widely accepted that a context-specific approach must be undertaken. This also means that an action that looks anti-competitive by object might fall short of this, at closer inspection, and vice versa. I shall revert to what this entails shortly, but first, we need to look at the Swedish ruling. Tapwell manufactures and sells kitchen and bathroom accessories, both online and in physical shops. In 2023, the Swedish Competition Authority concluded that Tapwell had infringed Article 101 by pursuing a policy of RPM. Tapwell disputed this, both that it was guilty of restricting competition and having engaged in anything that could qualify as an agreement regarding this. I will not discuss the matter of agreements further. Before the court, Tapwell presented several arguments in its defense, including a lack of interest in the retail prices and failure on behalf of the Swedish Competition Authority to contemplate whether Tapwell action had any anti-competitive effects. Regarding the matter of no effect, did Tapwell refer to limited market share, less than 15%, and how the retailers involved accounted for less than 0.2% of total sales? Usually, enforcers don't intervene against distribution agreements concluded between undertakings with less than 15% market shares. However, only if not confronted with an object restriction. Eventually, the court sided with the Swedish National Competition Authority, agreeing that Tapwell had infringed Article 101 by deploying an illegal RPM. Moreover, this was anti-competitive by object, dispensing with the need for proving effect. Regardless of confirming the RPM as anti-competitive by object, I read the ruling as paying lip service to my criticism of the traditional restrictive approach to RPM. I see the court as confirming the need to consider context of the arrangement, commanding a case-by-case approach, and opening for RPM falling short of being anti-competitive by object. I have already explained how RPM is not obviously anti-competitive and, as illustrated by the retail example, how consumers might also be better off when RPM is deployed. This does not mean that RPM cannot be problematic, only that it's too simple to view them as inherently evil, as implied when labeled as anti-competitive by object. No operative definition of object restrictions had been provided, but I read 3 recent sports cases establishing 3 categories. Those directed at bringing about the examples in Article 101, surrogate to these, and arrangements fragmenting the single market. None of these refers to RPM, and save for the single market, neither is capable of taking a vertical form, confirming the weak basis for intervening against RPM. The approach from the sport cases confirms the path of other recent cases, linking the concept of object restrictions to arrangements serving no legitimate purpose but restricting competition, and how a potential object restriction must be assessed in its context, including ability, but not for its actual effect. Combining these cases, we get a 3-step test for identifying object restrictions. Step 1. Is there a legitimate commercial explanation? Step 2. Does the arrangement pertain to central competition parameters, for example price or market access, and a form, making it capable of restricting competition? Step 3. Are the parties pursuing objectives covered by the examples listed in Article 101, surrogates to these, or a partitioning of the single market? Evaluating this could entail a context and a mini-effect analysis, including contemplating the counterfactual. Reverting to the Tapwell case. In reaching its findings, the Swedish court relied on 5 EU cases holding RPMs anti-competitive by object. However, all these pertain to online sales, and in guess, cross-border sales had also been regulated. I believe the decision to move forward with these had more to do with the single digital market than RPM. In the specific cases this overlapped, but confronted with different facts, I don't think the EU would have moved on the cases. Enforcers do not have to contemplate the effect, once a course of action is deemed anti-competitive by object. This follows from the presumption of yielding no consumer benefits and being inherently bad. EU case law has been rather persistent in this. Regardless, I read the Swedish court as susceptible to contemplating whether the arrangement actually had an appreciable adverse effect on competition, considering its limited coverage. I even read the court ruling as rebutting seeing RPM as anti-competitive by object per se, and without considering context and the object the parties pursue. This also means that, to the extent any criticism should be levied, it should be that the court did not adequately consider if the consumers benefited from the arrangement, for example, by allowing for the maintenance of brick-and-mortar outlets. However, as the court refers to the matter, this might be more of a question of unconvincing evidence. This does not mean that Tapwell is not guilty of restricting competition, nor does it preclude RPM from infringing upon Article 101 by object. It only means that this cannot be assumed without considering context and why the parties adopted the RPM clause. Tapwell denied having pursued any RPM policy and has appealed the ruling. In preparing this video, I googled Tapwell English domain address. I did this from Denmark, but was persistently redirected to the Danish version. Obviously, more research would be required before making any conclusion, but it does look like Tapwell prefers that you shop with your domestic suppliers. As you recall, Case law has identified actions defying the single market anti-competitive by object. So perhaps Tapwell is guilty of restricting competition by object. It just got convicted under the wrong theory of harm. In my presentation, I have relied on several rulings. References are here. As always, feel free to reach out.